Good day, student. I trust you are doing well. Today, I will be doing a summary of study unit 4, which is the variable consequences of a civil marriage, focusing specifically on marriages in community of property. Marriage in community of property is the default matrimonial property system in South Africa. That basically means that when spouses enter into a civil marriage, the presumption is their marriage is automatically in community of property unless if there are circumstances that's going to be proven otherwise, which will be discussed further below. When spouses are married in community of property, they become tied co-owners in undivided and indivisible house shares of all the assets and liabilities they acquire before they entered into a marriage and during the marriage. This means, for example, if you have an immovable property that you acquired before you enter into a marriage and you enter into an in community of property marriage, that immovable property will automatically forms part of your COP marriage. COP is community of property, and your spouse will automatically own 50% of that immovable property. That as well, if, for example, you enter into a COP marriage with a student loan, the student loan will automatically form part of the joint estate. There is a rebuttable presumption, or in order to, there is a rebuttable presumption, or in order to prove that your marriage is not in community of property, you need to prove these 3 factors. Firstly, you must show that the spouses must show that, or they must produce a valid anti-nuptial contract which excludes community of property, Secondly, they must produce a valid existing post-nuptial contract which excludes COP. And thirdly, if at the time of entering into the civil marriage, the husband was not domiciled in South Africa. In other words, although the husband was living in South Africa, the husband's nationality was not South Africa. It was not South Africa. Let's say, for example, it was Nigeria or Zimbabwe, where the default matrimonial property system are out of community of property. So this means that the default matrimonial property system that will be applicable to the spouse's marriage will be out of community of property. This is known as the lex domicile matrimony principle. The lex domicile matrimony at the time of conclusion of the civil marriage is very, very important. Let me just also give another example. If a South African woman marries a South African man, their marriage will automatically be in community of property unless if they've got an anti-nuptial contract, or they've got a valid, or they entered into an income of property and subsequently they change their matrimonial property system and they have a valid post-nuptial nuptial contract. The marriage, if they don't have those two, the marriage will automatically be income of property. But if when a South African woman enters into a marriage with a non-South African, let's say enters into a marriage with a Zimbabwean partner, the marriage will automatically be out of community of property, even if they don't have an anti-nuptial, contract, and it will automatically be out of community of property, even if they enter into a marriage in South Africa. The reason this is because the husband's matrimonial property system from his country, it is automatically out of community of property. In South Africa, South African women follow the laws of their husband's country. Now let's move into assets which do not form part of the COP. These are assets which are subject to the fiducium, usufruct, jocalia, which are engagement gift, benefits due to a married woman in terms of the Friendly Societies Act, non-patrimonial damages awarded to a spouse for a deed committed against him or her. Here it is very important to note that the non-patrimonial damages must be obtained or must be acquired while the spouses are in a marriage. If they are acquired before the spouses enter into a marriage, these non-patrimonial damages will form part of the COP. So the non-patrimonial damages must be awarded during the existence of the COP marriage. Then continuing, damages which a spouse receives as a result of a personal injury inflicted by the other spouse, and the cost awarded to either spouse in the event that spouses get involved in a matrimonial action with each other without dissolving the marriage. Those damages do not form part of the joint estate. It is important to note that the spouses who are married in community of property cannot sue each other. The only time that an action can be brought against the other spouse is when the other spouse has caused personal injury to the spouse who's bringing in the claim. That is the only time that an action can be brought against a spouse who is in an existing income of property marriage. The last assets which do not form part are proceeds of unlawful activities in terms of the Prevention of Organized Activities Act. It is important to note that the exclusion of the assets from the COP do not or are not protected when one of the spouses has been declared to be insolvent. So if the spouse is going through the process of insolvency, those separate assets will be taken into account, and all the assets that are in the joint estate, including the separate assets, will form part of the insolvency process. Now the liabilities. We've got three types of liabilities. We've got contractual debts, we've got intellectual debts, we've got anti-nuptial debts. Contractual debt. If a contractual debt is incurred by a spouse who has the capacity to bind the joint estate, that debt becomes a part. Who has the capacity to bind, like both spouses, that debt becomes part of the joint estate. The intellectual debt. If the debt is incurred during the subsistence of the marriage, that debt must firstly be recovered from the separate asset of the spouse who committed the delict before they can be recovered from the joint estate. So in other words, if let's say the spouse who committed the delict does not have a separate asset, in other words, assets which do not form part of the joint estate, then the person suing can now sue the joint estate as a whole. And the third debt, which are the anti-nuptial debts. These are debts which are incurred before the parties entered into a civil marriage and are not yet paid after the marriage has been dissolved. These debts must only be recovered from the original debtor. But if the creditor is suing while the parties are still married to each other, the creditor can sue the joint estate. Antenuptial debts are, for example, when you enter into a marriage and you had a student debt. So as I said, liabilities that you had before you enter into a marriage will form part of the joint estate. Now, protection of third parties. A third party who enters into a transaction with someone who is married in community of property is protected by Section 15, subsection 9, subsection A of the Matrimonial Property Act. If the third party does not know or cannot reasonably know that the person's spouse had to consent or the necessary consent was not obtained, the transaction is going to be deemed as have been obtained with the necessary consent. Now, remedies for a spouse who is unaware of the debts that are being taken by the other spouse. And also remedies for stopping from the other spouse from continuously making debt. We've got statutory remedies and common law remedies. Under statutory remedies, you must know that the spouse who wants the other spouse to stop taking the debt has the right to adjustment, or let's say the debts have already been taken. The innocent spouse has the right to adjustment upon the dissolution of the joint estate. Secondly, he has the right to request the court to stop the other spouse from actually having to give their consent without the other spouse's without the other spouse having to also to consent. Or alternatively, let's say they want the other spouse to keep on giving consent, and the other spouse is unreasonably withholding the consent. So they have the right to get the court order to request that they be allowed to consent without the other spouse. And then the other remedy is to request the court to suspend the other spouse's powers in terms of their joint estate, and to also order immediate division of the joint estate. And this immediate division, it is done without actually dissolving the marriage. The common law remedies includes interdicting the other spouse. It also includes a common law right of recourse upon the dissolution of the marriage. It also includes having the other party declared a prodigal, and also the extrapolina atalis, which this comes into play when an asset has been transferred to a third party with the fraudulent intention of prejudicing the other spouse. Okay, let's continue. Administration of the joint estate. As spouses are married in community of property, they both have the right to joint and equal administration. Husbands no longer have marital powers over their wives. When spouses who are in community of property, there are certain transactions that when they undertake, they must obtain either the written consent or verbal consent, or just, written consent with witnesses, written consent without witnesses. For example, prior written consent, which must also have two competent witnesses. This must be obtained, for example, if spouses are involved in an immovable property. In other words, there's an immovable property and the one spouse wants to sell and the immovable property. The immovable property cannot be sold without the consent of the other spouse. And then written consent also, when you take credit from the bank or from the creditors, the written consent of the other spouse, it is needed. And oral or tacit consent, it is required when you are alienating assets or immovable assets like furniture, receiving money, and all of that. And consent or no consent, or consent is not needed when a spouse does transaction in the ordinary course of their business. For example, let's say spouses are married, spouses who are married in community of property, and one spouse is a business owner, and in their business, they are also a director. When they undertake or when they make decisions in their capacity as a director, they do not need the consent of their spouse. For example, let's say they want to take a loan in the name of the business, or they want to sell certain assets, or even an immovable property which forms part of the asset of the business. They do not need the consent of their spouse, because they are selling that asset or that immovable property in their capacity as a business owner, and not necessarily in their capacity as a spouse. It is important that you understand how in community of property works, not only for just to make sure that you pass your exams, but as future jurists, future legal advisors, future legal practitioners, you need to know when a prospective client comes to you and they want advice on what does being married in community of property entails. You need to be able to actually advise them on what they need to know, and what they or on the advantages and the disadvantages. So please go through your prescribed textbook, go through the study guide, read the relevant case judgment, and read also the relevant tutorials, especially tutorial 201, where we summarize the recent and important case judgment that you need to know about. No, so this was just a summary of the favorable consequences of a civil marriage and being married in community of property. The next summary will be on being married out of community of property. Students, good luck with your studies, and good luck with your exam. Thank you, students, and have a good day.